Hi, welcome. It's time to learn to love procedure and the nuance of law. As I'm sure you've heard by now, DOJ prosecutors have given Trump a letter telling him he's the target of a criminal investigation into the attempts to overturn the 2020 presidential election. Trump's lawyers confirmed this in court. Trump also said he had a deadline, which has now passed, if he wanted to talk to the grand jury. Naturally, he elected not to address the grand jury. That may have been an instance where the advice of a good lawyer and his own instincts coincide. There are rare instances when the target of an investigation should speak to a grand jury. This isn't one of them. All right, reminder, there are three categories in grand jury proceedings. A target has been linked to the crime with substantial evidence. A target is likely to be named as a criminal defendant. A witness has no criminal liability at the moment, but has evidence that the grand jury needs. A subject is in between. There is some evidence, but not yet enough for a person to be considered a target. A subject could become a target or a mere witness. Here's what's interesting. No other members of Trump's inner circle received target letters, or if they did, they're not admitting it. Rudy Giuliani and John Eastman, when asked this week, said they had not received letters. This is interesting for two reasons. First, if you've been following Merrick Garland's explanation for how the DOJ is conducting this investigation, you know they're working from the bottom up. But if they indict Trump alone, it would seem that they skip a few steps. Second, prosecutors generally like to indict co-conspirators together. Indicting some co-conspirators, but not others, can show favoritism. It can also appear that one of the co-conspirators is being targeted. Okay, so what gives? Why is Trump the only top honcho with a target letter? Well, answering that question requires some speculation, and it can be hard to separate speculation from wishful thinking. With that disclaimer, I'll give it a try. Prosecutors may have secured guilty pleas from other members of Trump's inner circle. This means he could be indicted along with co-conspirators who have pleaded guilty and who are cooperating. Think how much easier this would make the prosecutor's case. Trump's co-conspirators take the stand and say, yes, I did it. So did Trump. Then they offer documents or records, including digital records. Documents and records are important because here's the thing about flippers. They are, by definition, insiders. When insiders flip, they're inherently unreliable because they're part of the criminal enterprise. A good cross-examiner can make them look unreliable, particularly if they're cooperating as part of a deal that benefits them. But documents and records can provide more solid evidence. Witnesses who are part of the criminal enterprise can provide documentary evidence that might otherwise be beyond the reach of prosecutors. They can explain the documents and records the prosecutor has. They can corroborate other witnesses. They can say what happened during key phone calls. They can explain a pattern of phone calls. Question: is Rudy Giuliani cooperating? Recall that not long ago, Rudy Giuliani did a 2-day proffer. Here is a good definition. In some federal criminal cases, a potential defendant may have information that may be valuable to prosecutors. In cases where the evidence against the potential defendant is airtight, such as where the client is on videotape committing an alleged crime, it may be in the client's best interest to cooperate with prosecutors and provide them with relevant information. Cooperation can also make sense when a potential defendant faces significant prison time, the risks of a trial are significant, and there's a good chance that they could receive significant benefits in exchange for their cooperation. The benefits could range from no criminal charges or a lesser charge, or prosecutors agree to request less time, or prosecutors could agree to request less prison time at sentencing. A proffer interview is the most common way to cooperate with the government in a criminal case. If the client has helpful information to offer, defense counsel will offer the client cooperation and negotiate an agreement. 2 days is a long time. A person can answer a lot of questions in 2 days. So it would seem that Giuliani had a lot to say. Basically, in a proffer, the defendant tells the prosecution everything he or she knows. Given the terms of these agreements, the prosecutors cannot use that person's statements against them in future proceedings, except for untrue statements which void the agreement. Offering information doesn't guarantee that the potential defendant will be offered a good deal, so they're risky and used only when a defendant knows he or she is in big trouble. On the other hand, immunization happens in this kind of an instance. A witness appears before the grand jury and refuses to answer questions by taking the fifth. Any person who believes he or she may have criminal liability can stand on the fifth. Well, if the prosecutors decide they want that person's truthful testimony and they don't care about prosecuting that person, they will immunize the person, basically saying, "We will not prosecute you." Once a person has been immunized, they no longer have potential criminal liability, so there's nothing to prevent them from talking. At that point, they lose their Fifth Amendment protections, and they either talk or they're in contempt. Smart people who don't want to go to jail or people with good lawyers are so grateful to be immunized that they talk. Rudy did a proffer, so we can assume he's in big trouble and is hoping for a deal. Now, it's hard to imagine Giuliani turning on Trump. But Giuliani has so many troubles right now. Lawsuits, he's in disbarment proceedings, he was given a letter telling him he's the target of the investigation in Georgia. It's possible that he said, "I'm done. I'll tell you what I have. Go easy on me." It's hard to find another motive behind a 2-day proffer. Next question. Is Mark Meadows cooperating? In a Washington Post piece published recently, we learned that during the summer of 2022, Mark Meadows was turning over text messages to the DOJ that nobody, not even the January 6th Congressional Committee, had seen. Now, check out this timeline. In the fall of 2021, initially, Meadows appeared to be cooperating with the January 6th Congressional investigation. Then, abruptly, he stopped cooperating. On December 13th, 2021, the J6 Committee, furious, referred Meadows to the DOJ for criminal contempt of Congress. They also referred Steve Bannon, Dan Scavino, and Peter Navarro. On June 3rd, 2022, we learned that the DOJ declined to prosecute Meadows and Scavino, but prosecuted Bannon and Navarro. The DOJ, naturally enough, did not explain why it prosecuted Bannon and Navarro, but not Meadows and Scavino. Then, in the summer of 2022, Meadows was turning over text messages to the DOJ. Here's what it sounds like to me. We know Meadows is a two-faced guy who wants to please everyone. He isn't particularly brave. In 2021, he complied with the January 6th committee because he does what he's told. Then he stopped. Well, why would a coward stop? Well, Trump does have a habit of threatening people. But Meadows might have been willing to talk to the DOJ because talking to the DOJ is safer. Everything the January 6th Congressional Committee did was public. On the other hand, grand jury proceedings are secret. They're private. And this DOJ is running a tight ship. There have been no leaks. This is from May 2023. A source close to Trump's legal team said Trump's lawyers have had no contact with Meadows and his team and in the dark on what Meadows is doing in the investigation, fueling speculation about whether Meadows is cooperating with the special counsel's probe or if Meadows himself is a target of the investigation. So, is Meadows cooperating? Is Giuliani making a deal? We don't know. We'll have to wait to find out. Okay. This is part of his trial schedule. On January 5th, he has the next E. Jean Carroll trial, which is civil. In March, he has the Manhattan hush money case, which is criminal. And in May, he has a stolen documents case, which is also criminal. Plus, we're expecting 2 more indictments, one from Georgia, and of course, one for the January 6th insurrection. You can see that Trump's 2024 trial dance card is getting full. So Trump's target letter listed 3 crimes. Now, keep in mind that the DOJ is not limited to the 3 crimes listed. Crime number 1, conspiracy to commit an offense or to defraud the United States. This is a general conspiracy statute. Conspiracy statutes allow prosecutors to cast a wide net. My mentor at the Federal Defender's Office, Mark Reichel, called it the darling of the prosecutor's garden. To get a conviction, the prosecutor only has to show that 2 people entered an agreement to commit a crime against the federal government and that one of them took a step in furtherance of that crime. Crime number 2, tampering with a witness, victim, or informant. Despite the name, this statute includes other crimes and has been used to prosecute January 6 defendants for attempting to obstruct a proceeding. This statute also includes a conspiracy element which reads, whoever conspires to commit any offense under this section shall be subject to the same penalties as those prescribed for the offense of the commission which was the subject of the conspiracy. Crime number 3, conspiracy against rights. This is the interesting one. Here's a good summary from the New York Times. Congress enacted that statute after the Civil War to provide a tool for federal agents to go after Southern whites, including Ku Klux Klan members who engaged in terrorism to prevent formerly enslaved African Americans from voting. But in the modern era, it has been used more broadly, including in cases of voting fraud conspiracies. Now, modern usage of the law raised the possibility that Trump, who baselessly declared the election he lost to have been rigged, could face prosecution on accusations of trying to rig the election himself. As journalist Marcy Wheeler said, we knew all along Trump and his pals were deliberately trying to suppress the votes of Black Americans. All you have to do is look at the cities he was targeting. The NAACP has been on it all along. They filed a lawsuit against the Trump campaign and the RNC for their efforts to discount the ballots of Black voters. So, will the indictment against Trump include this accusation? We don't know. We'll have to wait to find out. RICO. Really? We also learned that Fulton County DA Fani Willis is planning to charge Trump, and others no doubt, under Georgia's RICO statute. RICO stands for Racketeering Influenced and Corrupt Organizations Act. RICO statutes in general are designed to get to organized crime. The Georgia statute, like the federal RICO statute, requires 2 underlying crimes and a pattern that suggests a criminal organization. The difference is that under the Georgia statute, the underlying crimes can be any crime. The federal statute, in contrast, requires that the crime be in connection with the organization. So it's easier to charge racketeering in Georgia. And as you know, Trump does act like a mob boss. The 2 crimes Willis is reportedly considering are influencing witnesses and computer trespass. We all know about the steps Trump has taken to influence witnesses. Influence is much easier to show than, say, threatening. I don't think there's any doubt that Trump's call to Georgia's Secretary of State Raffensperger asking him to find the necessary votes for Trump to win would count as influencing. It obviously would. As far as computer trespass, remember when computers were breached in Georgia? Here's what happened. 2 months after the 2020 presidential election, a team of computer experts traveled to South Georgia to copy software and data from voting equipment in an apparent breach of a county election system. They were greeted outside by the head of the local Republican Party, who was involved in efforts by then-President Donald Trump to overturn his election loss. A security camera outside the election office in rural Coffee County captured their arrival. The footage also shows that some local election officials were at the office during what the Georgia Secretary of State's office described as alleged unauthorized access of election equipment. Well, so now you should all feel ready to read the indictments when they are issued. Yep, this is the Nerd Channel.